Good afternoon, everyone. Thank you for joining us today for our talk, which will be beginning shortly. For those who are here, thank you for waiting. We would like to share with you a short video from the firm before the talk.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Thank you, everyone. Welcome again. And thank you for joining us today for our online talk titled What to Know If You're Stopped for Drink Driving or Other Road Traffic Offences. My name is Eric To, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mao & Kuai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Mao & Kuai. Our able team today comprises of 27 lawyers and a support team of 21. Dato' Ma today is a consultant with the firm following his retirement from the corporate field bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which are also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 16th talk of 2020. Before I continue, please be reminded that this talk does not constitute legal advice, and in the event you require specific legal advice, please contact us for complimentary legal consultation. Details will be given at the end of the talk. We have two speakers for today. Firstly, we have Ms. Vivien Fan, and we will have Mr. Wong Chee, two of them. Vivien is a senior associate in our dispute resolution department and individuals and family department. She has a Bachelor of Laws from Cardiff University, and she was called to the English Bar in July 2016. She was admitted to the High Court of Malaya in 2017. Her areas of practice include criminal litigation, land acquisitions, general litigation, debt recovery, probate and administration of estates, contractual disputes, and tenancy disputes. As I mentioned, we also have our second speaker, Mr. Wong Chee. He is an associate in our dispute resolution department. He has a Bachelor of Laws from the University of Leeds. He was called to the English Bar in 2018 and admitted in the High Court of Malaya in 2020. His areas of practice include general litigation, construction law, criminal law, and medical and personal injury matters. Please, you are able to ask questions later and post your questions in the Zoom Q&A chat box. Please do not forget to type them in. We have 4 talk points for today. Mr. Wong Chee will be dealing with the first and fourth talk points, while Ms. Vivien Fan will deal with the second and third. And without further ado, I shall pass the floor to Chee for his first talk point. Over to you, Chee.
Thank you, Eric, for the introduction, and good afternoon, everyone. Let me just share my screen. Good afternoon, everyone. My name is Chee. As Eric mentioned earlier, I'll be covering the first and the last point, which is drink driving and its penalties. After this point, I'll pass on to Vivien to talk about reckless driving and also other road traffic offences before she passes on back to me to talk about your rights in general when you are stopped or if you're arrested, and also if you're charged in court. So let me just dive straight into the first talk point, which is drink driving and its penalties. Now, as you all would have known, drink driving, especially in Malaysia, has always been a cause of serious concern, especially when such an act leads to injury or even worse, death, to not just the driver or the passenger, but to other road users as well. Because of that, the government of Malaysia had already introduced a Road Traffic Amendment Act of 2020. This amendment is basically to impose heavier penalties in order to improve road safety. The amendments came into effect on the 23rd of October 2020. Now, let us have a look at some news before we go into the offences. The news regarding drink driving offences. So I have here 2 news that I have been able to find online. The first one, which is titled, "A Man Gets 4 years of jail, 15,000 ringgit for drunk driving." Briefly, this case is about a man driving under the influence of alcohol, and in doing so, he had caused the death of a policeman, and also it had caused injuries to others. After he was charged in court, he was found guilty and he was sentenced to 4 years imprisonment, 15,000 ringgit fine, and his driving license was suspended for 5 years. As I understand, this matter is being appealed to the High Court now, but we have no news as of today that whether or not this matter has been resolved. The defendant here, this man, is actually appealing against the conviction and also the sentence, as I understand it correctly. Now, moving on to the second one, which is police not letting up on drive against drunk motorists. As I mentioned to you earlier, the amendment of the Road Transport Act came into effect in 2020. So after that, or I'm sure everyone would have known that there will be a lot of roadblocks on the road, especially during Friday nights, Saturday nights, during the weekends. So the second news is about statistics from the KL Police Chief Commissioner, which says that the police had detained about 1,116 people for drink driving in June 2022 alone. And in Selangor, the police had detained, or rather arrested 255 people this year as well. There is another piece of statistics that I have, but I didn't put it in the slides. Basically, this is a statistic for last year. So the PDRM released this statistic saying that in 2021, roughly about 2,692 people were stopped on roadblocks. And out of these 2,692 people, about 1,250 people were detained or charged subsequently. So just looking at the news, looking at the statistics, you can see that there is still a large number of people who have been stopped for suspected drink driving, and most of them, they were subsequently charged in court. Let's move on to the offences, that are the drink driving offences. So there are 3 types of drink driving offences that you can find in the Road Transport Act 1987. Section 44, which deals with driving while under the influence of intoxicating liquor or drugs, and to such extent that that person is incapable of having a proper control of the vehicle, or that the alcohol in the body exceeds the prescribed limit. And the important part of section 44 is that the act of this person causes death or injury to any person. Now, section 45, on the other hand, is just being in charge of motor vehicles when under the influence of intoxicating liquor or drugs, and this person is unfit to drive or incapable of having proper control of the vehicle. Then we move on to section 45A. It deals specifically on driving under the influence of alcohol. So section 45A deals with driving or attempting to drive or being in charge of a motor vehicle with alcohol concentration above the prescribed limit. So this is just a brief, or rather the important elements that we have to be aware of. Section 44 again is driving the motor vehicle, being intoxicated with alcohol or drugs, and the alcohol, you have exceeded the prescribed limit and this causes death or injury. Again, section 45 is being in charge of a motor vehicle, being intoxicated with alcohol or drugs, and this person is unfit to drive and being incapable of having proper control. Section 45A is driving, attempting to drive or being in charge of a motor vehicle, and as long as the alcohol is above the prescribed limit, then you may be charged under this section. Now, before we go on to talk about the penalties of all these offenses, I just want to share with you this very important information, which is the prescribed limit of alcohol. So the amendment of the Road Transport Act, we can see that there is also an amendment to the prescribed limit of alcohol. So before the amendment to the Road Transport Act, the prescribed limit of alcohol is 35 micrograms of alcohol in 100 milliliters of breath. After that, after the amendment, is now 22 micrograms of alcohol in 100 milliliters of breath. For alcohol, the prescribed limit is 80 in 100 milliliters of blood. Now it is now 50 milligrams of alcohol in 100 milliliters of blood. In the case of urine, it is used to be 107 milligrams of alcohol in 100 milliliters of urine. Now it is 67. That means that with this reduced prescribed limit, even if there is lower consumption of alcohol, it is very likely that you may well exceed this limit. Just to give you a bit of context, so for blood alcohol content, so everyone reacts differently to alcohol. Some, the face may turn red, some they don't turn red as fast as the others. So there are also other various factors to consider, such as your gender, your weight, type of alcohol, either beer or wine, even stress levels is also one of the factors to consider. And just to share with you, it takes generally about half an hour, 1 hour for an adult to process 1 unit of alcohol so that none is left in the bloodstream. And to give you a bit more context, the standard alcohol unit is about 8 grams of pure alcohol. So about example that I've given here is 330 ml of beer. So it will be like maybe half a pint of beer and 125 ml of wine, or even 25 ml of spirit. Now, let's move on to the penalties. So Section 44 of the Road Transport Act, as I mentioned earlier, it deals with driving while under the influence of intoxicating liquor or drugs, which causes death or injuries. So if it causes death, it's going to be a separate or a different penalty as compared to if it causes injury. So let's deal with death first. So before the amendment, the imprisonment would be between 3 to 10 years, and the fine would be between 8,000 to 20,000 ringgit, and you'll be disqualified from holding or obtaining a driving license for a period of not less than 5 years for the first conviction, and not less than 10 years for subsequent conviction. Now, after the amendment, you can see now that it has been increased, is heavier now, that the imprisonment for the term is between 10 to 15 years, and you will be fined 50,000 to 100,000 ringgit. And also you will be disqualified from holding or obtaining a driving license for a period of not less than 10 years from the date of conviction. Now, for subsequent conviction, of course, it's going to be heavier. The imprisonment will be for a term of 15 to 20 years. The fine will increase up to from 100,000 to 150,000, and you will also be disqualified from holding or obtaining driving license for 20 years from the date of conviction. What about an offense which causes injury? So before the amendment, it is slightly similar, 3 to 10 years imprisonment. Fine will be 8,000 to 20,000, and you will be disqualified from holding or obtaining a driving license for a period of not less than 5 years for first conviction and not less than 10 years for subsequent conviction. After the amendment, it will be imprisonment between 7 to 10 years, and the fine will be 30,000 to 50,000 ringgit. And also you will be disqualified from holding a driving license for a period of not less than 7 years from the date of conviction. And in cases of subsequent conviction, the imprisonment will increase to 10 to 15 years, and the fine will be 50,000 to 100,000, and also you will be disqualified from holding a driving license for 10 years from the date of conviction. So that is section 44. Now we move on to section 45, which is being in charge of motor vehicle when under the influence of intoxicating liquor or drugs. Before the amendment, the fine is not exceeding 1,000, and you'll be imprisoned for a term not exceeding 3 months. And for subsequent conviction, it is a fine between 2,000 to 6,000 ringgit, and also imprisonment of term not exceeding 12 months. But after the amendment, the fine has increased from between 1,000 ringgit to 5,000 ringgit, imprisonment for a term of not exceeding 2 years, and you'll be disqualified from holding a driving license for a period of not less than 2 years from date of conviction. For subsequent conviction, it will be a fine between 5,000 to 10,000 ringgit, and imprisonment for a term not exceeding 5 years, and also you'll be disqualified from holding or obtaining driving license for a period of not less than 2 years from the date of conviction. Now we move on to the third of the section, which is for section 45A, which deals specifically on driving or being in charge of a motor vehicle with alcohol concentration above the prescribed limit. So before the amendment, it is for the first conviction, it will be a fine between 1,000 to 6,000 ringgit, and imprisonment for a term not exceeding 12 months. For subsequent convictions, it will be a fine between 2,000 ringgit to 10,000 ringgit, and imprisonment for a term not exceeding 2 years. Now, after the amendment, the fine has increased from 10,000 to be between 10,000 ringgit to 30,000 ringgit, and imprisonment for term not exceeding 2 years. And you will also be disqualified from holding or obtaining a driving license for a period of not less than 2 years from date of conviction. For subsequent conviction, again, it is a fine between 20,000 to 50,000, imprisonment of not exceeding 5 years, and also disqualified from holding a driving license for a period of not less than 5 years from the date of conviction. Now, there are not many reported cases regarding drink driving offences, mostly because I think most people would have pleaded guilty to the charge, and that is why there's not too many reported case laws. But this is one of the case laws that I would like to share with you all, and I think it's very important to be aware of this. So in this case of the public prosecutor against Chiu Jing Zhong, he was charged under Section 44 of the Road Transport Act. He raised a defense saying that he did not know how much he had drank. So the court eventually found him guilty, and the court actually said that a person who has been drinking cannot claim ignorance of the amount of alcohol that he has consumed. And also any attempt to rely on his own judgment that his ability to drive has not been impaired will be futile. So you cannot say that just because you drink 1 pint or you drink very little alcohol and you judge by yourself that you can drive, doesn't mean that you will not or you may not be charged under any of these sections under the Transport Act. The court went on to say that Section 44, Section 45A are both interrelated in the sense that the alcohol content beyond the permissible range in the body as per the law is a total prohibition from driving. As I mentioned, he has been found guilty. The sentence passed by the court was that he had to serve a custodial sentence of imprisonment for 42 months from the date of conviction. He was fined 9,000 ringgit in default of payment to a further 6 months of imprisonment. And his driving license was disqualified for 5 years from the date of conviction. So that is generally the overview of drink driving offences and its penalties. I will now pass on to Vivien to talk more about reckless driving and its penalties. Over to you, Vivien.
Thank you, Chee. Thank you for the insightful sharing. Hold on, let me just share my screen. I'll just share a little bit with all of you on the offence of reckless driving under the Road Transport Act, especially with the new amendments that came into force end of 2020. Reckless driving, the legislation has divided it into 3 separate offences. Section 41, where a death of a person is involved. Section 42, no death, just driving recklessly. And Section 43, which is a lighter offence where a person is found driving without due care and attention or without reasonable consideration. Let's briefly look at the penalties of each of these offences. Pre-amendment and post-amendment. Section 41, causing death by reckless or dangerous driving. Before this, it was only imprisonment for a term of between 2 to 10 years. It's been increased to 5 to 10 years. Fine of between 5,000 to 20,000. It's been increased to 20,000, from 20,000 to 50,000. And disqualification used to be 3 years, and now it's been changed to 5 years. Section 42, which is reckless and dangerous driving without causing any death. Previously, imprisonment for a term of 5 years, that remains. The fine has remained as well, and disqualification increased from 2 years to 5 years. Section 43, driving without due care. Previously, it was a fine of between 4,000 to 10,000. Now it's been increased slightly from 5,000 to 10,000. The imprisonment remains the same, which is not exceeding 12 months. So what is reckless driving? Let's have a closer look at how the judges have interpreted reckless driving. Driving recklessly. Let's look at Section 41 specifically. Driving recklessly or at a speed or in a manner having regard to all the circumstances, the nature, the condition, size of the road, amount of traffic, which is dangerous to the traffic, which causes the death of any person. So under Section 41, there are 4 elements if you look at it closely. Number 1 is driving recklessly, or if you are driving at a speed which is dangerous, or if you are driving in a manner which is dangerous, and you have to cause the death of a person. Unfortunately, or fortunately we can say, the legislation does not define what is driving recklessly or what is driving dangerously, rightly because whether a person is driving recklessly or dangerously, it very much depends on the conditions, the facts and circumstances of the situation at hand. Whether it was dim lighting, whether the conditions of the road, whether there were potholes, whether there were any road signs, warning signs, caution signs, all these are taken into consideration before the court decides whether you were actually driving recklessly or dangerously. So let's have a look at how the court has interpreted it. So the High Court in March 2021, which is a recent case, in interpreting what is driving recklessly, he's referred to the Lord Deplock judgment in R versus Lawrence, which held that it is recklessly describes of a physical act which can be performed in a variety of different ways, some entailing danger and some not. It refers not only to the state of mind when he or she decides to do that particular act, but it also qualifies the manner in which the act itself is actually performed. So the court will look at your state of mind, the state of mind of the driver, and the manner in which the driver was actually driving. So he went on to say that one does not speak of a person acting recklessly, even though he has given no thought at all to the consequences, unless the act is one that presents a real risk of harmful consequences, which anyone acting with reasonable prudence would recognize and give heed to. So a summary of what it actually means is that A person cannot be said to have acted recklessly unless the act created or presented a real risk of harmful consequences or the dangers which a reasonable prudence person will recognize and give heed to, which means you have to drive dangerously or recklessly. By doing so, when you do, you did not think of the harmful consequences which may actually occur, which a reasonable person would have took caution. So the judge said, the corollary is that if a person's act does not create or present a kind of real harmful consequences or dangers that a reasonable prudence would recognize, the fact that the person is reckless does not make him an offender. So another case that is worth sharing with you is Ng Babcock versus Public Prosecutor in 2017, where the judge said that the test is an objective test in deciding whether the accused was driving dangerously. The test to be applied is an objective one and not a subjective one. So the opinion of the accused whether he was driving dangerously is immaterial. Of course, right? Because every driver will say that, no, I was safe. I wasn't driving dangerously. So the test is objective in determining the manner in which he or she was driving. The test to be applied is whether an ordinary or reasonable person in the driver's shoes would have actually, having regard to all the circumstances, actually think that it's dangerous or not to do. So driving dangerously may involve speeding or reckless driving. The danger may be either real or potential. To drive dangerously must involve some fault. So the fault does not need to involve either deliberate conduct or intentional, as long as that driver actually committed it. Here you go. It says fault involves a failing below the care or skill of a competent, experienced driver. So reckless also constitutes the manner of driving. It is willful disregard for safety of other road users and a willful disregard of the consequences of such driving. The High Court in Mat Atan has actually separated the offence into two elements, which the prosecution will have to prove, which is actus reus, the act of driving recklessly, and mens rea, the state of mind of the driver when he or she was driving dangerously. Right? In deciding the actus rea, the judge held that it seems to me that actus rea of driving recklessly, which the appellant was charged, having regard to all the circumstances and the amount of traffic which is all might be expected to be on the road, is dangerous to the public and caused. The risk of the danger to public must be obvious and serious to an ordinary, reasonable, prudent motorist, which is an objective point of view. The danger is something worse than creating just a risk of causing inconvenience or annoyance. And the mens rea, which is the state of mind of the driver, is that he or she must have given no thought at all to the possibility of there being such danger or risk to public. Or he or she has thought of the risk, would have recognized the risk, but nevertheless went on to take the risk. And that is in itself recklessness. So the judge actually took a reasonable point of view, which is that, of course, it is not possible to go into the brain of the driver to determine his or her state of whether he or she is reckless. It can only be inferred from what the driver was seen to do and any statement that he or she may have made. However, such inference or recklessness may be rebutted by the explanation and evidence of the driver. I think maybe a distinction needs to be made between driving recklessly and driving dangerously, because Section 41 refers to both. Reckless driving, as this High Court judge has interpreted, is that the driver must have created an obvious and serious risk of injury to the person or damage to property and must have given no thought to the possibility of that obvious risk, or have foreseen the risk but nevertheless decided to take it. Dangerous driving, in contrast, is that the prosecution must establish that a situation created by the accused is dangerous, i.e., such as turning right to the road without stopping to give way to traffic, and when creating such situation, the accused was at fault. So fault involves, as I explained earlier, falling below the care and skill of a competent and experienced driver. So then, as Chee has explained just now, there are not many cases post-amendments, either because most of the accused plead guilty and pay a fine and just plead guilty, or it's because the amendments are quite recent, so not many judgments have been published as of now. But we'll just share with you one of the reported cases is Kan Sum versus Public Prosecutor 2022, very recent. So the accused drove his car recklessly on a highway, which collided with a convoy of 4 cars, and this resulted in the death of one of the passengers in one of the 4 cars. So he was charged for reckless driving causing death under Section 41. So his defense was that he was going the wrong way, his car couldn't slow down, even though he has pressed the brakes, and the steering wheel was stuck in a lock position. So they went through trial, and the accused was convicted of the offence, sentenced to imprisonment for 2 years and fined for 7,000. As usual, he was also disqualified from holding his driving license for 3 years. So they both appealed, both the driver and the prosecution appealed to the High Court. The High Court dismissed both appeals and held that the sentence is not manifestly inadequate or grossly excessive, or not in accordance with law, because the magistrate had overarching interests of the general public against the interests of the accused. And the magistrate had also considered the worrying trend of reckless driving in the country and realized the need for courts to send a strong deterrent message against it. I think the reason why we're sharing a little bit on reckless driving with you today is also because of the renowned case of public prosecution against Sam Kerting. That was the Basikal Lajak case. So as all of that case involved per driving at 3 a.m. in the morning and hitting 8 children, causing the death of a few, what happened in that case was that initially when that case was brought to court during prosecution stage, the magistrate actually held that the prosecution failed to prove prima facie. So a few factors were taken into consideration. Number one is that the conditions of the road were okay. Although the lighting at that time was a bit dim, one of the street lamp was broken, the conditions of the road were okay. The road was safe to drive. There were 3 very broad lanes, and she was driving on the most left lane, where the accident actually occurred right in front. They also found that she wasn't driving very quickly. Her speed was only at about, I think, 44 kilometers per hour. They also found that she did not lose control. There were no signs of squeaking brakes or tire marks on the other 2 lanes. She was driving according to all the reports. She was driving properly. The conditions of the road was what the magistrate found that, which prevented her from being able to see what was ahead of her. So it was actually a hilly road, and there was something like a crest at the top of the hill, and the children were at the bottom. So unless and until she reaches the top, she would not have been able to see the children at the bottom. And the magistrate found that actually it wasn't her who created or who caused or who was driving recklessly or dangerously. Instead, it was the children who created a dangerous situation for road users, and including her to drive on that road. Such as the judge went on to talk about how the windy road and the dim lighting prevented her from being able to see the children. The children were racing down the hill illegally, modification of the bicycles. The judge went on to talk about how this Basikal Lajak racing is illegal and it's caused a difficult and dangerous circumstance for road users. So at the end of it, she actually discharged and acquitted Sam Kerting on these few reasons, which I'll share with you. Number one, the accused could not have foreseen the presence of the group of children. It was 3 a.m. in the morning, it was hilly. The children have created a situation which causes risk to road users themselves. The road had a changing speed, which was from 70 km per hour to 50 km per hour, but there were no clear road signs, no caution signs. In any event, she was driving below 50 km per hour. Her sight distance was also obstructed by the gradient slope. And the magistrate found that the IO's investigation was not complete and has raised reasonable doubts because the IO, whose evidence is very important, actually found that she was not driving on the left-hand side, but in the middle lane, when everybody else's evidence said that she was on the left lane. Because of all these situations, the magistrate said that the prosecution has failed to prove prima facie beyond reasonable doubt, and hence has discharged and acquitted her without having her to enter its defense. So the prosecution appealed 2019, appeal was allowed by the High Court, remitted back to magistrate for her to enter her defense, went for trial again. Again, she was acquitted and discharged. And then the prosecution appeal, that was the most recent case in April this year, where the High Court sentenced her to 6 years jail, 6,000 fine, and license suspended for 3 years. So I think from this case, what we can glean from this case is that it's very hard to determine whether the person was driving recklessly or not. Yes, her act or his act of driving may look or seem dangerous or is actually dangerous, but in order to be convicted under Section 41, which carries a very heavy sentence, his or her state of mind has to be reckless as well, that he or she has paid no regard at all to the safety of other road users. There are many cases where accused are charged under Section 41, but later when it went on trial, the court found that the prosecution has failed to prove that he or she had a reckless mind. Then the court will usually sentence under Section 43 of the Road Transport Act, which is driving without due care and attention, which attracts a lower penalty. That's my sharing with you on reckless driving. I will now quickly go through the other common road traffic offences which you may already are aware of, which is using mobile phones while driving, speeding, failing to observe traffic lights, driving on emergency lane, and driving without a valid road tax or insurance. So using mobile phones while driving, Section 17A, it attracts a fine of not exceeding 1,000 or to imprisonment of a term not exceeding 3 months. Based on my experience, most of the time it only attracts a fine. Rarely the court will send you to prison, especially if it's the first offense. Number 2 is speeding. Section 40 attracts a penalty of a fine between 300 to 2,000. Number 3, failing to observe traffic lights. Section 79 of the Road Transport Act, a fine of between 300 to 2,000. So these offences are compoundable offence, which means that you have to go to court and plead guilty and pay the fine in court. Number 4, driving on emergency lane. That's Rule 53 of the Road Traffic Rules 1959. Attracts a penalty of 2,000 or imprisonment for a term of not more than 6 months. Driving without valid insurance attracts a fine of not more than 1,000 or imprisonment of not more than 3 months or both, and possibility of disqualification. So all these little minor offences, most of the time it only attracts a fine in court, especially if it's the first offence. Okay, so now I'll hand it over to Chee to share with you on the police powers and what you can do, what are your rights during an arrest, remand, and bail. Over to you, Chee.
Thanks, Vivien. Let me just share my screen now. I'll briefly talk to you about what powers do the police have and your rights during arrest, remand, and bail if you are subsequently charged. So what happens if you are stopped by a police officer at a roadblock, suspected of driving under the influence of alcohol, driving recklessly, and what happens if they ask you to carry out a breath test because they suspect that you have been drinking? So these are the things that you would need to know, regardless of what sort of offences that you may be suspected of. It applies to all kinds of offences if you're stopped on the road. So again, in the situation where you are stopped in a police roadblock, what you need to do is you need to slow down, pull over, if you are instructed by the police officer to drive to one side, and the police officer will talk to you about, may request some information from you. You can see if the police officer is not in his uniform, you may request for his or her identification. And it's important to take note of the relevant information, such as the name, the rank of the police officer. But in usual roadblocks, the police officers would have been in uniform. So what you need to do if you are stopped is that you need to cooperate with them. If he asks or he requests that you do a breath test, you need to cooperate, unless if you have a reasonable explanation to refuse. Now, if you are informed that you have failed the breath test, you can either seek clarification or ask to do a second test. Some people, they will ask to do a second test, maybe in the police station. So let's focus more on about this breath test. So under the Section 45B of the Road Transport Act, the police officer shall have the power to ask you to, or compel you to carry out a breath test if he or she has reasonable grounds to suspect that you have been driving or attempting to drive under the influence of alcohol. The breath test can be carried out at the roadblock, as I mentioned earlier, unless if he thinks that this should be done in the police station. There are certain circumstances where the police officer may require you to do a second breath test, or maybe some other tests such as urine or blood tests that would have been done in a police station or in a hospital. So it depends on whether or not the police will ask you to do second test. I should also inform you that under Section 45B of the Road Transport Act, if you do not have any reasonable excuse to refuse the breath test, if you refuse to do the breath test when you are required to do, this is an offense by itself. So under Section 45B of the Act, this may attract imprisonment for a term not exceeding 2 years and a fine between 10,000 to 30,000 ringgit. And you will also be disqualified from holding or obtaining a driving license for a period of not less than 2 years from the date of conviction. So this is something that you should be mindful of. So regarding arrest, so Section 45B, subsection 5, subsection A of the Road Transport Act says that a police officer in uniform may arrest a person without warrant if, as a result of a breath test, he has reasonable cause to suspect that the proportion of alcohol in that person's either breath, blood, or urine exceeds the prescribed limit. Now, what about your rights as an arrested person? Let's say in a situation where you have been arrested, you're in the police station right now. So what do you need to know? What are your rights? So you have to be mindful of your own rights. You need to know what are the grounds of arrest, what are they arresting you for. You have the right to seek legal advice. If the police wants to question you about a suspected offense, you can inform them that you want a lawyer present with you before you answer any question. You also need to be aware that you can only be detained for 24 hours only. Of course, the police might want to extend the remand process, which I will talk about later. But in terms of being detained, the first part will be to be detained only for 24 hours. You have the right to remain silent during the interview. And also you have the right to communicate with a friend or relatives to inform them that you have been arrested, or maybe they want to visit you to bail you out. So you have the right to a phone call to communicate with a friend, relative, or to seek a legal representation. Now, as I mentioned, so if the police thinks that they want to detain you for more than 24 hours, there are two options that the police can do. One, after 24 hours, they have to release you if they don't have if they think that they have done the necessary investigation, they either release you, or if they think that they want to detain you for a longer period of time, what they need to do is they will need to bring you before a magistrate. Sometimes this will be in court, to apply for a remand order to extend the detention period for further investigation. This is provided for under Section 117 of the Criminal Procedure Code. How long can this remand be extended? The police officer can apply twice. So offences which are punishable with imprisonment for less than 14 years, the first remand order will be not more than 4 days. And if they decide to apply for a second remand order, it can be not more than 3 days. For offences which are punishable with imprisonment of more than 14 years, Section 117 sub 2 sub B of the Criminal Procedure Code says that first remand will be not more than 7 days. Second remand order is also not more than 7 days. Of course, there are exceptions, which are Drug Dependence Act and also Immigration Act, which we're not going to talk about today. This is just for your information. If the police decides to extend the remand, they will need to bring you before a magistrate to apply for it. At that time, you can actually be represented. You can get a lawyer to be there to oppose the remand. Basically, the lawyer's job at that time would be to inform the court that such remand isn't necessary. There is no need to extend the remand. If anything, this person will cooperate with the police, will attend to the police station if and when necessary. So if the court decides, let's say if the magistrate decides that the remand shouldn't be extended, then the police will have to release you after that. Yeah, so as I said, so after the end of the remand period, the police officer will either release you if they think that they do not have enough evidence to charge you in court, or if they think that they have, then they will bring you to court to be charged. What happens when you are charged in court? So this is just a chart that you can see if you are being brought to the court to be charged. The general procedure, the overview of how the court system works is that the court will first ask you whether or not you intend to plead guilty to the offense, to the charge. So if you say you want to plead guilty, and then the court will record a conviction and proceed to sentencing, and then you get to mitigate either by yourself, or you can get a lawyer to mitigate for you, basically to ask for a lower sentence. So road traffic offences such as what Vivien has mentioned earlier, using mobile phones, driving without driving license, or the insurance is expired. These kind of things, these kind of offences, we generally, in our past experience, we tend to see a lot of people pleading guilty to it and just record a conviction and ask for the lowest sentence possible. But in a situation where you intend to plead not guilty, what will happen after that is that you basically want to claim trial. That means you have to get witnesses to come to support your evidence, and of course the prosecution will have to first prove their case, and then after that the defense will be called. If the court thinks that the defense needs to enter the defense, then the defense will have to call the witnesses to support the evidence. So during that period of time, what a person can do is to consider applying for bail. If you don't apply, that means you'll be detained, either in prison, pending the course of the trial. So what is bail actually? So in the case of Yusuf bin Muhammad, its public prosecutor in 1995, bail simply means that security taken from a person to appear on a fixed date before a court. In other words, bail is to be understood to set a person free who is under arrest, detention, or is under some kind of restraint by taking security for his appearance. So the court may release you on certain conditions pending your next court appearance, for example, asking for a sum of, let's say, a few hundred or even a few thousand ringgit, depending on the seriousness of the offense. That is security, and that you give your undertaking to ensure your next court appearance throughout the trial. As you may have known, trial can take a few months or even years to conclude. So at that period of time, bail may be necessary for you to be released, and then, but at the same time, you need to attend the next court session. So how do you obtain bail if you are actually pleading not guilty and you want to claim trial? We will talk about bailable offense, since today's topic is about drink driving, road transport, the offenses under the Road Transport Act. So we will just focus on bailable offense, which is a person charged under bailable offense shall be released on bail as of right. The court cannot deny you bail unless, so these are usually less serious offenses, like I said, for example. So for example, offenses which carry imprisonment of less than 3 years. So all road traffic offenses are bailable offenses. There is another type of offense which is called non-bailable offense, but we will not talk about that today. If you are in the situation where you're in court, you're being detained, you want to apply for bail, the court will require you to get someone, either your friend, your family members, your relatives, to be there to act as a bailer. So who can be a bailer? He must be an adult Malaysian citizen. For foreign accused, the bailer shall be a Malaysian citizen, and that the bailer understands all the conditions imposed by the court. So what is the role of the bailer? The bailer's responsibility is actually to ensure your next attendance in court. As I have mentioned here, if you fail to attend, the bailer will have to attend court to explain why you did not attend. And also the sum that has been paid to court will also be forfeited if you fail to attend the next court date. Of course, it really depends on the offense. It really depends on whether the court impose any other kinds of conditions. So the court, I've given here some examples. So the court may impose other types of conditions. For example, if you have to report to the police station a few times on a weekly basis, or if you have to surrender your passport, these kind of conditions. So the process of applying for bail is that it will be processed in the court registry. The bailer will have to give his or her information, his name, his IC, his accounts, and the court will thereafter explain the conditions of the bail and to the accused. And after that, the bail will be executed. what happens if you breach the conditions of bail? As I mentioned earlier just now, the bailor would be summoned to court to explain your non-attendance, or the court might decide to issue a warrant of arrest for your non-appearance in court. Bail sum will be forfeited, or the court, if the court thinks that they want to revoke the bail, the court may do so as well, or alternatively to impose stricter or harsher conditions during your next appearance in court. So that is basically an overview of your rights. I hope you have found that useful. Let me just stop sharing. I'll pass it back to Eric.
Now it is question time. Thank you very much, Chee and Vivien, for your insightful talks. Please remember to drop your questions into the Q&A box. If you frequently find yourself getting stopped by police, I think this is a good time to ask the questions that you want to our panelists so that you know what to do. I think we do have a couple of questions already lined up here. So maybe I'll begin with the first question. Sorry, let me just stop sharing first. All right. The first question is, in Miss Sam's case, I think this refers to the case mentioned by Vivien. She was subsequently found to be driving recklessly. Isn't her quote-unquote reckless driving caused by illegal motorbike racing by the teenagers?
Hi, this is Lawrence, I believe. Hi, Lawrence. Hey, it's not, you can't say it was caused, her reckless driving was caused by the illegal motorbike racing, because technically speaking, you're supposed to look at the conditions of the road, of everything else at the time when the accident happened. So what the High Court found when the High Court allowed the appeal was that she should have driven even more carefully, even slower, especially based on the condition of the road at the time, which is it was hilly. She couldn't see what was at the bottom of the hill, so she should have driven even slower, and because it was 3 a.m. in the morning. So the High Court, one of the very few grounds given by the High Court was just that. So now that she has filed an appeal, we will see how the Court of Appeal decide on this case. I hope that answers your question, Lawrence.
Okay, thank you, Vivien. So Kaishin asks whether apparently Kaishin has heard that police purposely tampers with breathalyzers and not calibrating it before any tests. Have you heard of, or have we heard of any such cases? And if so, how should one deal with it if that happens? Vivien or Chee?
Thank you, Eric. I'll take that.
Yeah.
Hi, Kaishin. Whether we've heard of police purposely tampering or not, it's not of any concern here. But if you have doubts as to whether the breathalyzer has actually been properly calibrated, you would know how much alcohol you would have consumed. You would know more or less whether you have hit the minimum level that is allowed in your body. If you have doubts as to the accuracy of the breathalyzer, most of the case, before the police decides to charge a person, the breathalyzer is done at the roadblock. Then after that, they will do either a second breathalyzer at the police station, or they will do a urine or blood test. If the police does a second breathalyzer and that second breathalyzer also, you doubt the accuracy of it, then plead not guilty, fight for the case. And then we will challenge on whether it was properly calibrated or not. You would know yourself whether it's actually been calibrated properly or not. Yeah, I hope that answers your question.
Thank you, Vivien. I think the next question is also somewhat related. So the question was from Lau. The question is, for drunk driving, how would you confirm that the test kit is calibrated properly? Chee, do you want to?
Yeah, I think it will be similar to what Vivien has mentioned. Request for the second breathalyzer test, or even asked to do either urine test or blood test to check the accuracy. Of course, if you still have any doubts, then and subsequently, if you are charged, then of course the next thing is to plead not guilty to the charge, and then to claim trial and to challenge the accuracy, or to challenge that the test kit has been calibrated.
All right. Okay. Thank you, Chee. Next question is by Mr. or Miss Anonymous. What are some examples of reasonable excuses for refusing a breath test? Chee, what are the reasonable excuses that you can think of?
I think On the top of my head, if you are not feeling well, that is a reasonable excuse, especially now during COVID. This can be one of the excuses that I can think of, unless Vivien, if you have any further input on this.
Yeah, medical conditions, or if you think that it may trigger asthma or anything like that, then you can refuse. But of course, you don't give an outright refusal and say, oh, I have a medical condition, I cannot do this. You can actually say, okay, I cannot do this, but I am willing to take the urine test or the blood test, provided, of course, you know that you're innocent lah. Then we see what happens at the police station. But yeah, because it is an offense if you refuse to take the test when you're being asked, as Chee has explained.
All right, thank you, Chee and Vivien. It looks like there is no more questions unless I'm missing some parts, but it looks like there's no other questions. Maybe I give another 10 seconds. If no one, oh wait, we just have, seems like there's another question came in from Lau. In the police station, what if they change your urine? That is fascinating. Yes,
I think it's the same answer. I will give you the same answer, which is that if you suspect that they tamper the evidence, and if you're very confident that you are not drink driving, then prove that in court later. Challenge the evidence later in court. Plead not guilty and challenge it. Yeah.
Of course, I just want to add, you don't try to argue with the police at the time. You don't try to make a fuss out of it, because as I said earlier during my slides, it is actually an offense if you are obstructing the police officer in doing their work. So what you can do is, like what Vivien said, challenge that in court, not during the time when you suspect them of doing so.
Okay, so basically, don't admit to anything. Fight later, fight in court, basically.
Yeah, that goes especially for drink driving, because now it attracts compulsory imprisonment. Based on our experience, it can vary from 1 day to 7 days and a minimum fine of 10,000. So if you think that you're very confident that you were actually not drink driving, you didn't drink that as much as the reading shows, then fight for the case. Don't just plead guilty. Of course, it comes with costs and expenses, but that's for you to be decided later lah. Yeah.
All right, thank you. I think there are no further questions. So unless our panelists want to have any final, then I think we can end our session here. Before we end, I'd just like to have a final few messages. First, thank you again for joining our talk. Please join us again for our upcoming talk, which is in October, 19th of October. The topic title is Forced Resignation versus Constructive Dismissal. And the speakers will be Carolyn and Navin. So it's quite an interesting topic. Please tune in if you are available. Secondly, please fill in our feedback form and tell us what you thought of our talk. And the link to the form will be posted in the chat. Do follow and like our social media accounts as well, which I have on screen. And if you'd like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. We thank everyone again for joining us today, and we hope you have found today's session informative and useful. Thank you, and see you at our next talk.